was quizzed about it. He's spoken to various media organizations, and his first reaction was that the commission was actually very surprised to hear that judgment, in that regard, and that he did not expect it, but in any case, it has happened. So I think we'll listen to First He's saying that they were actually surprised when they heard that judgment.
Well, the judgment came to the commission as a surprise. But by the provisions of Section 143, subsection 1 of the Electoral Act, we cannot move in terms of making any move to conduct any form of fresh election or any form of by-election until the expiration of 21 days. Because the law says that if the aggrieved party files an appeal within a period of 21 days from the date of the delivery of the judgment, that the Independent National Electoral Commission should wait until until the candidate exhausts his or her constitutional right to appeal. And it also says that during this particular period, the candidate in question will remain in office until the determination of that particular matter. So the commission will not even take any step until the expiration of a period of 21 days. If at the expiration of 21 days, the candidate does not appeal and the commission does not appeal, then the commission will now be under a constitutional and legal obligation to conduct the said election within a period of 90 days.
Well, basically, the governor has actually come out to react. He said he will appeal the ruling, and moving forward, he has announced that his lawyer has been instructed to file necessary papers. So obviously, the governor is appealing this judgment, and it's going to be another line of judgment and another, because is it going to be a case of Bayelsa State is now going to be without a governor until the appeal of the governor?
No. In matters like this, if High Court rules, for instance, the tribunal rules saying that the governor has been nullified or his election has been nullified, there is what is called an automatic stay of execution, just like Professor Okoye said. It means that, yes, the judgment has come, but the judgment will not be executed for 3 weeks. So within those 3 weeks, the person who is the subject of the judgment has the chance to appeal. So the moment the person appeals, then that state of execution, it now crosses over to the appeal court. But you continue to act in your capacity as the governor until, if you win at the appeal court and then it goes all the way to the Supreme Court. That is when, let us assume we are considering that the Supreme Court now upholds this. Then, of course, we will see a situation where INEC will be forced to go and conduct an election within 90 days.
Okay, here in verbatim, this is the word of the governor. I could read in quotes: "We trust in the judiciary and we are appealing the judgment. With God on our side, we will get justice. This is a court of first instance, and I have instructed our lawyers to file an appeal. We have a right of appeal even up to the Supreme Court."
Exactly, and that is accurate. But the party in question, what happened? The INEC are saying that these guys, ANDP, submitted the name of a candidate, the deputy gubernatorial candidate. And according to the laws of the country, you must be 35 years and above for you to hold that position, the governor or deputy governor. And the candidate was 34 years old. Good. Now, INEC said, they wrote back to them, they wrote to them saying, this man is not eligible to contest. Okay? But the party wrote back to her and said, okay, yeah, we understand that he's not eligible, so we want to change the name of the person for another person. And interestingly, even the person that they changed was also 34 years too. So INEC wrote back and said, no, the window is already closed. So we will listen to INEC saying that the ANDP were actually informed. They were not flying blind.
No. We, on the 13th day of September 2019, the commission wrote to the political party in question, drawing the attention to the fact that they submitted the name of an underage candidate as their candidate for the deputy governorship of Bayelsa State. And we drew the attention to the fact that under Section 177B of the Constitution of the Federal Republic of Nigeria, which is the fundamental law of the land, a candidate for the post of governor or deputy governor must attain the age of 35 or above before such a person can be qualified to contest for that particular position. Now, the party itself, on the 21st of September, replied the letter written to them by the Independent National Electoral Commission relating to the invalidity of their nomination by saying, we acknowledge the fact that we submitted the name of an underage candidate. We now submit the name of a new person to replace the underage candidate. We submitted his name. And the commission wrote back and said, no, the candidate's name you submitted was invalid from the ab initio, and the period for nomination had already closed. And therefore, you cannot replace an invalid candidate with another candidate. And that was exactly what the commission did. And so we informed them.
A clear explanation on the reason for the disqualification. But I have a question to ask. Did INEC monitor the primaries of this party? There was a primary.
Yes, there was a primary. But who says that even after primaries that isn't after primaries when they start displaying
your candidates name, list of candidates,
your credentials on the INEC website and everywhere, that they say this is a period, if you know there is something wrong with this person, you come and say. So if the person in question, for instance, is an ex-convict, for instance, and the INEC was not aware then, and someone comes and says, so sorry, this person is an ex-convict, this person was convicted, went to prison, so is therefore like, what will happen? Of course you're disqualified. So that what the lawyers will answer this further, but the opinion I'm giving is as a result of my conversation with people who are very familiar with issues like this. Some people have drawn parallels and pointed to the case of SDP in Kogi
State. Yes, does INEC have the power to disqualify a candidate?
That is where the argument is. Some lawyers say they do, other lawyers say they don't. This issue has been litigated and re-litigated in courts, and I have the feeling that this could actually be a landmark issue if it goes all the way to the Supreme Court.
Yes, then the judgment is going to be the standing order for this kind of issue.
Exactly. Now, but when INEC was asked if they actually did the right thing, like, did you do the right thing? Because INEC has a legal department, and Festus Okoye himself is also a lawyer. Remember, he's a well-known, well-respected lawyer in Nigeria. He states his opinion. He said the commission is very convinced that they did the right thing.
Yes, as far as we are concerned, on two issues. One, we did the right thing because the Constitution couldn't have tied our hands so much to the fact that a political party will nominate somebody who is a foreigner, who is a Chinese or from Ghana or from Indonesia as a candidate, and the commission will hold his hands. As far as we are concerned, Section 31 of the Electoral Act, the proviso to Section 31 of the Electoral Act talks about the commission not rejecting a validly nominated candidate. The issue is the validity of the nomination. And if you look at Section 187, subsection 1 of the Constitution, it says that the governor must nominate a validly qualified candidate. The validity of the governor and that of the deputy governor must never be in question whatsoever. So as far as the commission is concerned, the commission did the right thing.
Now, what is coming in is this going to look like, a little opportunity for this party, ANDP, right? ANDP. Because just a few weeks, a case was in court on the disqualification of some political parties that could not meet up deregistration, I beg your pardon, that could not meet up to the requirement of being a political party, and this party was among these parties before the final judgment came in, where the court ordered that INEC does not have the right.
No. There were two conflicting judgments from two courts of appeal.
That's the issue. This is what I'm saying. If they're going to go by I think the second judgment that says INEC do not have the right to deregister political parties, is this going to be a win on their side? But if they're going to go with the other judgment that states automatically that they are disqualified, what is it going to be for them as a political party and this judgment right now?
Yeah, I think ANDP are fighting for their lives here, or for their existence as a political party. I was listening to the National Legal Advisor, Barrister, and he was waxing very lyrical about how they were disenfranchised, how they did not have the authority to remove them from the ballots, and all that. The party was formed in 2018. And in February this year, I think, the party was practically deregistered among the other 74 political parties. And that was in the aftermath of the election, Yeah, in the aftermath of the election, yes. Now, they have gone to court. The court has even recognized them as a political party, first of all, so that is 1-0. That is, they've already won a small victory.
Accepting their case.
Exactly. Now, the court has said, INEC, you don't have the authority to remove this person. That is another small win for them already. Until the case is appealed and completely dealt with maybe at the appeal court, if it will go all the way to the Supreme Court, I don't know, but with political cases in Nigeria, usually they always get to the Supreme Court.
Supreme Court is the final.
They rarely ever stop at the Court of Appeal. You know? So, if this party, ANDP, eventually win, it will now raise a lot of questions.
For the other parties.
Not only for our legal jurisprudence and our electoral offense. Now, first off, the law is clear. If you are not 35 years and above, you cannot contest an election as a governor. That is gubernatorial and so the governor and deputy governor. That's what Is the court now going to say that any party can field somebody who is
lesser?
Do you get? What is, when you say validly nominated candidate, if someone did not meet the requirements, can the person be said to have been validly nominated? So these are questions. Some lawyers have said, no, INEC does not have the power. Others say, yes, INEC does have the power.
That's what the bone of contention is right now. They want to know if INEC is bestowed with that power to disqualify a candidate of the party.
So we'll talk to our lawyer friend here, Barrister Dennis Harrison, and we'll find out, if INEC does have the power or not to disqualify a candidate based on a candidate or a party based on law. Good morning, Barrister Harrison. Good to have you this morning.
Good morning, Ben.
Okay, I believe you've been following the developments in Bayelsa State with interest, as the likes of us have also been doing. First off, when the judgment from the tribunal, there was a dissenting judgment, by the way. When you read about it, what was your first reaction?
Yeah, for me, I said breaking news. For me, I just felt not again. I just feel that the people deserve the opportunity to be served by the political elite. So not having this intermittent interjection interference by the court, you begin to see that the people are the worst for it. Because these electoral officers are being distracted from rendering services to their people. That is just the way I see it. So it came to me as another form of distraction for the political situation in the Bayelsa State.
Okay, but in any case, I have said that they actually, did the right thing in disqualifying that particular party on the basis of an invalid nomination. Okay, what is your legal position on that?
Like so many other things, I disagree with the opinion of Mr. Festus Okoye. I said this advisedly. We have said it often and over and over again. That the power to make a final determination of the right and obligation of any citizen, corporate or national, lies with the court and not with INEC. I don't know what else, we must draw this into the ears of those that are managing the decision of INEC. They must understand that the judicial power in this country is vested in the court of the land, not in them as INEC. Just to monitor and manage the election and, especially before the election, but after the final submission of rights or obligations of citizens, whether political parties or persons or natural persons, lies with the court. So, like in this case again, the court re-emphasized, the majority decision re-emphasized that, political that some of us, that INEC does not have the exclusivity or the absolute power to determine the rights or obligations of political parties, just like in this case. So, the INEC, in my opinion, were wrong about the issue to have excluded the political party from the process, knowing fully well that the power lies with the court.
Okay. So basically, you're saying you just basically answered my question that INEC does not have the power to disqualify a candidate.
Absolutely, that power lies with the judiciary, with the courts.
But INEC monitors election. They are the one that make sure that the qualities the candidate should possess, that the candidate possess that qualities. So are you saying that if INEC should come across a candidate that is not eligible, INEC shouldn't say a word? They should move on with the election because they don't have the power to disqualify that candidate?
That's what the authorities on the point are saying. INEC must even the constitution of the land. And thankfully, the court has not vindicated us to say that INEC has no such power. They were wrong for the political party. Just like the court also held now that they didn't have the power to disqualify the NDP in Bayelsa State. So the parties, there are several organs, in this country as established by the constitution. Judiciary, the power to adjudicate between parties, between citizens and individuals in this country lies only with the court. So the final determination of rights or obligation lies with the court and not with INEC. So INEC is not the alpha and the omega when it comes to election or the electoral jurisprudence. They are not. INEC cannot self-regulate. That's the point. Whatever INEC does is subject to the review of the court of the land. In this case, from the Supreme Court. So INEC cannot always come to the public to that claim self-righteousness and say they are always right. No, that's the case. So they must realize that whatever they do is still subject to scrutiny and judicial review, and what happened in Bayelsa State. So to follow up on INEC, yes, you have made a very valid point that we have to wait to the end of the process before the party, going up to acting like a court, over this political party. We're not done with the permanent, we're not done with the nomination, so people, fix the process. They don't make useful suggestions because we look at very, very clear that INEC must monitor the processes that lead to the amount of the candidate. What are they doing with the oversight? What are they wait for an election to come and then begin to make it close? For me, I believe there's a conspiracy going on somewhere. INEC is conspiring with some political actors. So discomfort within our electoral jurisprudence. We keep having these issues over again. Me as a Western, the problem must not come out clearly, make an amendment to clearly tell us what INEC should do in situations like this, so that to avoid the self-attack on guessing and then give us the self-attack people to come to disrupt the very system that has to be put in place.
Okay. So I'm going to pose maybe a question, or if you like, we'll listen to Festus Okoye. What he said clearly, he said, INEC cannot sit idly and watch a political party nominate, for instance, a Chinese or an Indonesian or a foreigner, and then say, okay, we do not have the power by as you are saying, and therefore we should allow things go. If a situation comes up where a party does not nominate a valid, or a candidate is not validly nominated by a party, are you saying that INEC should sit by, idle and wait, or is that litigating it, knowing how long our court cases are?
Absolutely, I would take the second leg of your proposal. You have asked the question. What INEC should do when the party has acted in illegality? It's such a crime. It's for political matters, you look at the time bound, and there is a special preference for the family political matter. It is expeditiously. So why is INEC saying the way from approaching a court of competent jurisdiction? So the family put the one question. Why are they sitting at the court over their own matter? Remember, you cannot see a judge in your own court. INEC cannot see a judge in a judge court. So if you feel a party has acted in violation of the electoral act or the constitution, what INEC should be doing going forward, going by this recent sense of personal INEC should be the right to approach the court and ask the court to declare that nomination invalid, even if there has been violation of the electoral act or the constitution. And to say that INEC can sit in the office and then give to the family who is qualified and is not qualified, because he's saying that power according to Section 6 lies squarely with the design of the land and not INEC or any organ or creator of statute. So the government is parties with priority, right? Squarely with the court and not with INEC. So INEC has a legal department. INEC is a public corporate. They can approach a court and put this question before it comes to competent jurisdiction, and it will be determined expeditiously because it's the political matter and time bound. So for them to sit back their office and wait for them to be concluded, and then with the way of the hand, just say that you have already court is telling them again today that they don't have such power, they don't have such privileges. Power rests solely with the judiciary and with the court of the land.
All right. Finally, before I let you go, what modifications or changes would you love to see in the Electoral Act to clear up stuff like this?
Well, absolutely. For me, the reason why we keep having things like this is because we have not strengthened our, the INEC, themselves. We're not giving them, we're not strengthening them, but giving them the way we want to ensure that they do proper monitoring of the electoral process. Because this program starts from the very beginning when a date is announced for the election, and then somebody starts, people that already primaries, and then you lead to the nomination of kind and all that. So INEC must begin to prepare for elections, not this lead data that they're currently employing. They know that they have a calendar of elections in the country. Why don't they start educating the political parties themselves and introduce them, they should explain what the law says to them. They should know what is the part of them to present a candidate. They must not allow this person to make this error, and then they now go to at the end of the day to now begin to come to some of the loopholes. I believe INEC must be ritually independent. They should stop disrupting the electoral process in this country. So if they know that a party is not doing the right thing, they should find out from the very beginning. If possible, approach a court or competent jurisdiction and ask the court to declare that the activity illegal, not to wait for the matter to be concluded and then begin to now allocate power to themselves that they don't have. So as a matter of suggestion, the electoral should be amended, and there must be a clear provision re-emphasizing the fact that there are certain powers that INEC cannot exercise, because those powers are vested in the court of the law. And INEC must also know that their actions or inactions must be subject to scrutiny and review, and that review will be done by the tribunal or any competent court of decision in the law. So that notion that INEC is an independent body and therefore they are law to themselves, they must use their mind and know that they are a creation of statutes, and what the law has provided for. INEC must repair the provision of the electoral act in the constitution strictly sensu to the letter. That's the only way we cannot having that history electoral process, as opposed to what we keep having information here and there. Once the thing is done, the country remains the last hope of the common man. When there is an electoral injustice, everybody has the right to approach a court, canvass your case, and once to make a credit, that becomes the law. But now in Palestine, the NDP is not going to rule for NDP. They must understand that they must have the level, competence, the capacity to see the process through. The tribunal will give them victory. Who knows? Because of it, tomorrow may have done that decision. Even the Supreme Court may have done it. So the NDP must not begin to celebrating or jubilating. They must be able to go through the process and even go to the Supreme Court before the final decision is taken. But before I end, let me also make a comment that I don't know why the APC in Bayelsa State is jubilating even more than the ANDP. The APC has been determined with finality, because the Supreme Court has rules that they didn't have any kind of, they didn't know the very kind of start election. The Supreme Court, the land has rules, so that has determined the right of privilege of the APC. So I don't know why the APC people are not being the ones celebrating the judgment in Bayelsa State. They don't want to come. So, just in my personal opinion, I believe that the APC must be a stable election, but not their own election. The election should be between the other parts that were not found wanting, in the case of the APC in Bayelsa.
Okay.
So the government was now going to the drawing board and going to review the process. If they want to against John, they should do that. So that the Supreme Court wants its opportunity of determining with finality the power of INEC when it comes to issues like this.
All right, thank you very much, legal practitioner, barrister Dennis Osaraitin. Thank you for sharing your legal opinions with us this morning.
Thank you, Mr. Chairman. Thanks for having me. God bless you, those days.
All right. Okay.
So basically, it means that if it's a fresh election, you don't think
It's not a matter of you don't think. The Supreme Court has already removed it.
it's a fresh election.
No. Every single lawyer I've spoken to about this issue have taken the time to say, look, you don't really litigate on something that the Supreme Court has already ruled upon. That's why they say they are the final court. Okay, the court has already said this party will not. In fact, they didn't take part in the election. Just remove them already. So even if they are going to have some, it's going to be among those that had validly nominated candidates and all that. So, but in conclusion, I think we'll have to listen to Festus Okoye berating parties and saying that, look, parties must always pay attention to the legal, provisions provided for in the Electoral Act.
Well, you see, this particular matter was not the only matter relating to this particular issue after the 2019 general elections and other subsequent elections. Around 6-7 political parties that were also affected, that nominated underage candidates, also took the Independent National Electoral Commission to court in a pre-election matter, and the court determined these matters in favor of the commission. Now, we are convinced as a commission that this matter falls squarely within the view of Section 285, subsection 14C of the Constitution, which gives the Independent National Electoral Commission certain powers, and also states that issues relating to the nomination of candidates and disqualification of candidates in relation to their nomination are pre-election matters. But going forward, the Commission has taken care of all these issues, and that was why in the nomination portal that the Commission created for the filing of nomination by political parties electronically, the Commission has made it in such a way that no candidate and no political party can file the nomination for an underage person, because the moment you want to log in and you input the date when the candidate was born, and if the candidate is underage, the portal will never accept such a candidate. So we have taken care of such a situation. But one thing is very clear: political parties must pay attention to the constitutional provisions relating to qualification and consult their legal advisors when they are in doubt. You cannot go and nominate a candidate that is 12 years old or to be your deputy governorship candidate.
You can't nominate someone who is 12 years old to be a deputy governorship candidate. But why did they not put these things in place before? Anyways, they say necessity is a mother of invention.
But one question: Do these political or politicians who put themselves out, candidates to run for a position, do they know that they have to have a lawyer?
Look, every political party must have a legal advisor.
Yes, they do. But how well do they, carry them along, or is it just, go out there, put yourself out? Because what he said here looks like most of them don't even carry their lawyers or legal advisor along.
I can't hold me for the politicians. I mean, they are the ones who want to become governor, not me. So they should know that their lawyers must. There are legal provisions in the law that says if you're not 35 years and above, you cannot contest. It's a no-brainer. It's there. You just know the law says if you're an ex-convict, you cannot. It's there already. These are things. Sometimes I feel like some of these politicians, sometimes they just want to steer on the hornet's nest, and all that. But it's not in my place to start questioning them and their legal advisors.
Alright, it's time to let you into the conversation. You can call us right now 0706-263-9275, 0903-939-4427, and 0812-178-9154, or send a text message to 0807-400-9076, or join us on WhatsApp on the number 0812-178-9154. 30 seconds to each caller.
Hello, good morning.
Hello, good morning, Charles.
Morning to you. What's your name? Where are you calling from?
I'm Francis from Benin.
You're welcome, Francis. Go ahead.
Alright, concerning the extra election that was notified. Because, are you hearing me?
Yes, we can hear you. Go ahead, please.
Okay. If the court order fresh election, that is all that have been done before, concerning election by SRP, is possible. What we had to contest.
So,
we take court, you declare that they are not qualified to contest. Now that election is qualified early, and they need fresh one. I think that the person to contest again. That is supposed to be.
Okay. Anyways, I'm happy you said that is how you think it's supposed to be. But in any case, thank you very much. It's not how it is. How you think it's supposed to be is not really how it is. Hello, good morning.
morning. Hello.
Good morning, ma'am.
Good morning to you. What's your name and where you're calling from?
Yeah, this is Barcelona.
Barcelona, welcome. Go ahead.
Yeah, I just want to appreciate you guys and the lawyer that spoke to us this morning. I'm grateful for what you said. That's it. Thank you.
Good morning. Hello.
Good morning.
Good morning to you. Welcome. What's your name?
Yeah, this is Issue Blues calling from Mission Road.
Alright, go ahead.
So talking about that action, I think listening to the station on conference where they were like, let's do that, the video is supposed to do, and it's concerning them, and someone was like, there's no provision for them to stop. They're supposed to go through the course with the tech and this person. Then the other person, the other person was like, if a person brings a 12-year-old man to contest as a government, the party should, the commission should do it, or that one is the to evaluate this issue. It's the same first election for me, if I don't understand it. First election, are you saying that every other parties who have not participated can now show interest? Are you saying the party should go and now start doing the primary elections, and what have you? So I don't think that is the way. So to me, the issue of APC is done and dusted because the Supreme Court has already condemned them. Because if you go by the word flesh, it means that any other party that was not showing interest then cannot show interest. The primary should begin to take place. And so it means that it's another place for the lower place. But for me, APC matter has no any place here, even if at all. The Supreme Court has judgment. Thank you.
Thank you so much.
Well, primaries cannot take place anyways, just so you know.
Alright, let's quickly look at the messages we have on. Okay, let's take a message. Let's take a call. Hello, good morning.
Hello, good morning.
Welcome. What's your name and where are you calling from?
My name is Chooks. I'm calling from Benin.
Alright, Chooks, welcome. Go ahead.
I think this judgment is not the end of the judgment. I think the PDP candidate can still go to appeal for the appeal to Supreme Court. I think that the Supreme Court that will give the final judgment. And what is happening now, it shows that our INEC, they need to work out and do the needful. They support them independent, they are not independent. At times they work on people that put them in power. So they should live with that independency on them. But not after election, spending big amount of money. This is taxpayer money. This is not money. If they do want to conduct an election, it's got to take another huge money. And people try to take the law because it will be or die after again. We don't want that to be happening in our resources. That's my contribution. Thank you.
Thank you so much for your contribution. Now,
That's a very
valid point. Another amount of money being,
when that question was posed to him, he said, well, if it comes to the commission will look for a way to get the money from somewhere. That's the answer he gave.
Alright, let's go to the messages. Good morning, KUFM. I think politicians should be well grounded about the electoral laws before coming to contest elections to avoid all these issues of disqualification. Collins from Benin. Good morning, KUFM. I am Lagos man Orosanye from Ego Axis. Bayelsa State Election Judgment. INEC man Professor Festus Okoye has earlier cautioned the ANDP as a party that its candidate is underage when filling papers. The age limit is supreme in this case. Thank you, KUFM. Why must INEC waste its resources in litigation to dump a candidate that is clearly unqualified? This is Etino, sir. Good morning, KUFM. I am Jeremiah Gole in Orogo, Ovia Northeast. God bless you guys. I'm disappointed. What happened in Bayelsa is a shame on our democracy. After the Supreme Court, which is the highest court in the land, has given its verdict, tribunal went ahead to nullify an election. May Almighty God help us. And good morning. Okay, this is definitely not for us. And the last message here before we call it a day on today's show. Hi folks, according to Mr. Okoye, INEC followed the constitution. Does it mean the constitution does not work when INEC make use of it? Ima from Benin. I can't understand the question though.
You know, it usually, most times, have you ever heard INEC taking anybody to court before? It almost never happens. It's INEC that is almost always on the receiving end of court cases.
Post post-election.
Pre and post-election cases at the time.
Mostly post sometimes.
Now, the day we called Mr. Leo Sazeuzi here, and he said INEC had about 668 or 69 court cases that they were facing at the same time. So they are the ones who are always on the receiving. Maybe they should start, like Dennis suggested, they should start taking these parties and their candidates to court themselves.
This is where we really cutting on today's edition of Dialogue. Do well to join us again tomorrow for another wonderful edition. Coming up next in 2 minutes is the news update. I am Godlove Orlando.
My name is Charles.
Good morning.